Okay. All right, so let's start chapter 2. As I told you before, chapters 2 and 3, they are the very basics of the law. Remember chapter 1, skip it, you may read it. It talks about the relationship between the client and the lawyer, but not for exams. So in chapter 2, we're gonna look at the introduction to the legal system. In other words, we're gonna define what law is. And once we define the law, we're gonna look at sources of law. Where do laws come from? And we're also going to look at the two legal systems that are present in Canada, the legal, civil legal system and the common law. And we're going to look at the Constitution. Constitution is usually the most important law at a given country. This is the case for Canada too. And then we'll finish the lecture by going through protection of rights and freedoms and protection from discrimination. So let's start defining law. What is law? And in law school, we could spend 2-3 months to discuss the definition of law in terms of modern, historical, sociological, etc. But here we go straight forward. What is law? Law for us will be this body of rules. And I say body of rules because there are several rules, different rules, but they are rules that can be enforced either by courts or by governmental agencies. So when do courts enforce a law? When do courts apply law? Anyone? Any guesses?
When it breaches another party's rights.
Okay, but why is a court reaching someone else's rights? What do courts do in general? Okay.
They protect the rights.
Okay, they protect rights, could be, but to go in a simple way, can we not say that courts, they make decisions? When one sues the other, a judge will make a decision. I am suing you because allegedly you owe me 10,000. So I'm going to sue you. The court will decide either I win or I lose. So when courts are making decisions, when they are adjudicating cases, when they are looking at cases, they are enforcing law. They are enforcing this body of rules. Also, if you are a foreigner, who's a foreigner here and arrived in Canada? Okay, so when you arrived in Canada, you probably arrived by plane. Did you not go to the immigration office? So the immigration officer that works for one of Canada's governmental agencies, they applied law to you so that you could have a study permit issued or a work permit issued or a tourist visa issued, right? So those are examples of either courts or governmental agencies applying law, applying this body of rules. Okay, there's also, if you were in Canada last April, you may remember that May 1st was the deadline to submit income tax. Again, CRA, Canada Revenue Agency, they are applying law, the Income Tax Act and Income Tax Regulations, to require us or people who had money, who received money, well, under their requirements, to submit an income tax. So those are examples of law. When a police officer pulls you over, you're driving, police officer pulls you over. They do this because of the law allows them to do this. So those are examples of law. Are we good? Those are examples of this body of rules. But like in my house, I have a 14-year-old daughter. I don't allow my daughter to watch TV and eat at the same time. That's my rule. Is this rule law? Is my rule law? What do you think? No, it is not. If we say my rule is law, when I catch my daughter watching TV and eating at the same time, I should sue her. Or I should call the police, right? But that's not law. That's just my rule. Like in this course, we have rules, we have deadlines, we have attendance rules. But those are not laws that are enforced by courts or governmental agencies. Are we good? Right. Law and morality. This is important. Most laws in Canada, they have good moral value. But I said most, not all. And also, I'm saying good moral value. But it may be good for me, good or not as good for you. May be bad for you. So what I mean here is that not all laws will carry the same moral value for people, because people have different cultures, different backgrounds, different values. Let me give you an example. January this year, in BC, someone who is caught with up to 2.5 grams of cocaine has not committed a criminal offense. It is not a criminal offense in BC to carry up to 2.5 grams of cocaine or other synthetic drugs. For some people, this law has good moral values because it addresses, for the government, for example, it addresses the overdose crisis, or it helps address the overdose crisis in BC. For others, this law does not bring good moral values because they see now people carrying cocaine and it's not a criminal offense. They believe people will consume more and more. But it's still the law. Does it make sense? So some laws will have values, most laws actually, because laws are passed by courts, laws are passed by the government. Those are all, government is elected by the population, by citizens in general. So most laws, because of this, they have good moral values. But law and morality, they are not synonymous. Okay, they may be different. So that's the first definition. Now we will categorize law. We'll categorize law as either substantive or procedural, and either as public or private. Let's start with substantive law. What is substantive law? It is our rights or obligations. So you said you're foreigners, you came to Canada to study. If you are enrolled in full-time courses or full-time equivalent, as a student, you are allowed to work. This is, why do I know this? Substantive law. Substantive law tells us what our rights are or what our obligations are. So if you were working in Canada last year for at least 6 months, you have to file income tax. It's an obligation. Where does this come from? Again, substantive law. So substantive law is my rights or my obligations. Whereas procedural law is about the procedure, is about the steps, is about enforcing substantive law. So if you have full-time equivalent study or program, you are allowed to work. That's your substantive law, you're right. But how do you enforce this? So procedural law will tell you what documents you have to provide to the immigration officer, what fee you have to pay, what's your deadline, So what the requirements are, so the procedure. Okay, let's talk about income tax. Income tax. So if you have worked for at least 6 months in Canada last year, you may have to file income tax. You may have had to file May 1st. How do you file? What documents do you provide? The T4, T4A, any other forms your banks will give you. This comes from procedural law, how you do it. Okay, one last example. Students who take courses at different educational institutions. Let's say a student took business law or equivalent to business law in another educational institution. When they come to BCAT, they may have a right or obligation, but in this case, right, substantive law, to be exempted from business law here. But does BCAT exempt them automatically? No. Procedural law will say how they will be exempted. They have to apply before the course starts, what documents they have to provide, what fee they have to pay, who they have to talk to, where they have to apply to. Are we good? So that's difference of substantive and procedural. And then we have public and private law. Now we're talking about matters of law. There are matters that are of public nature. There are other matters that are more of a private nature. So that's the main difference here. Public law is any law in which the government has a relationship. The government and the people. Is the immigration officer the government, a representative of the government? Yes, they are. So immigration law is an example of public law. Is the police officer a representative of the government? Yes, they are. That's criminal law. It's another example of public law. And then we have others. We have constitutional. We have taxes paying for the government to manage our money. Administrative law. So those are examples of public law. In other words, public law deals with the relationship between the government and the people, or vice versa. Okay. Whereas private law deals with more private nature issues. So it will deal with relationships among people and private parties, private institutions, private companies. Okay. So examples here will be property law. So during the break, you went to the washroom during the break and I did not use your laptop. Why not? Because property law tells me that it belongs to you. You cannot use it. It's private between you and I. Tort. Tort is compensation. We're going to see tort next week. So if, let's say, I throw my smartphone at your laptop and your screen is broken. You had a damage. Now you sue me to recover the damage. That's tort. So it's private again. Can those matters also relate to the government? Sometimes it can, like when there are governmental corporations. But in general, private law deals more with private parties. And we also have contracts. So BCAT, they hired me. It's private relationship. When you get a job, when you buy something, those are examples of contracts. So in this course, we're going to look a little bit at constitutional and administrative law, a little bit. And everything else will be private law, because this is a Canadian business law course. Okay? We will not be dealing with criminal law. We will not be dealing with tax. Okay? This course is more about private law. Are you following? Are you okay? All right, so now let's talk about the two legal systems that exist in the world. Most countries, they have only one legal system. the case for my country, it's the case for the US, England, France, Germany, several other countries. But Canada has two. Canada has two because of Quebec. Quebec, they have their own legal system. Only for private matters, not for public. Only for private matters. So for private matters in Quebec, the legal system is called civil law. So the legal system that is called civil law is based on a code. There's a code. Code that is usually thick. There may be more than 2,000 sections. And the code deals with substantive and procedural law for private issues. So the civil code is a book, is a code that tells us what our rights are, what our obligations are, what the procedures step by step will be. So in Quebec, if judges, governmental, government sometimes, but private parties and the judges, if they need to know what the law is, they refer to their civil code. That's why I have a picture of a code here. So that's an example of a code. So you just open the code and you see sections that are related to the matters you are interested in. That's the civil law system. Okay, my country in Brazil is also civil law, the whole country. So in Brazil, we have a civil code that has more than 2,000 sections. And we lawyers, judges, we rely on that code. The same in France, the same in Germany. And this civil law from Quebec actually derives from the French civil code. Okay. So that's everything I'll tell you about the civil law legal system. Because our main focus in this course will be the common law legal system, the other legal system. This legal system is present everywhere else in Canada, including BC. And because we are focusing in BC, so this is the most important legal system for us. So in a common law legal system, the main characteristic is that judges, when they render decisions, their decisions become law. It doesn't mean there are no codes or no written law in a common law system. Yes, there are. But the main characteristic is that some decisions of judges, they are law. They are source of law. And this is another reason why I told you to read the case summaries from the textbook. Because most of the case law that you have in the textbook, they are important decisions. They are source of law. So we lawyers, let's say you hire me as a lawyer to sue someone else. So when I'm making my legal submissions, when I am drafting the legal documents, I will tell the judge that you have a right based on those precedents, as we call precedents or case law. And then we refer the name of the case law because they are a source of law. Not all decisions are law, but some of them are. Okay, so that's the main characteristic. And this system derives or comes from the British, from England. And the concept that some decisions are law derives from stare decisis. Stare decisis says that decisions from higher courts, they are binding on lower judges, lower court judges. So on Wednesday, when we discussed the court hierarchy, a court system, this will be clearer to you. But as of now, keep in mind that some decisions based on the stare decisis principle, they are binding. Judges are required to follow them. Those decisions that become law, they are known as precedent or case law or past decision. So those three names are okay. Precedent, case law, or past decisions. And both the civil code in the civil law legal system in Quebec for private matters, the civil code and precedents in the common law system, they allow parties to predict the outcome of the decision. Parties will not be certain about the decision. It's not about this. But parties will have an idea of what the decision may be. So again, you come to a lawyer and you say, hey, this is what happened to me. I want to sue the other party. The lawyer will say, well, based on the precedents for your case, I don't think you will win this case. The lawyer is not guaranteeing you will lose. No, the lawyer is just saying that based on the precedents, based on past decisions, you may lose. But the decision to sue, to start a lawsuit or not is yours, is the client's. Or the other way around. The lawyer may say, oh, based on the precedents, your chances of winning are high. Again, the lawyer is not guaranteeing you will win the lawsuit. The lawyer is just saying that chances of winning are high. The decision is still yours if you want to sue or not. Okay? All right. So now when we talk about equity, equity is mostly important not where they were created, but it's important because the equitable principles, they are still applicable nowadays. Equitable principles, equitable remedies, they are originated from the Court of Chancery years, centuries ago. But this Court of Chancery doesn't exist anymore. So it's irrelevant for us because they have merged with the common law courts. What is important for us is to remember in future lectures that there may be equitable remedies that the judges will allow. I'll give you just one example, and I may repeat this example when we talk about contract. So in most cases, when one party sues the other in court, in most cases, the party suing is seeking for money, for monetary compensation. Most cases. But sometimes money is not enough, or money is not the best decision. So my example is my neighbor and I, we have an agreement that no one will erect a wall that will block each other's view. So if my neighbor starts erecting a wall, I want to sue my neighbor. After negotiating, etc., if my neighbor insists with the wall, I want to sue them. But I don't want money. I want my view back. Right? My view back means that the judge will order my neighbor to stop violating our agreement. So it's a stop order, stop money, it's a stop order, stop violating the agreement you have and bring that wall down. So a stop order is also known as injunction, is an example of an equitable remedy. Okay, but I will repeat and I will discuss about those equitable remedies again in the future. For now, just keep this in mind. And as I told you, common law, the main characteristic is that precedents, past decisions, they are law. They are one source of law, the main source of law. But it doesn't mean there are no other types of law. There are other types of law. There are statutes, there are acts. There's legislation that is made by the parliament or provincial assembly or bylaws passed by the city council. So there are other laws. Okay, we'll discuss about them in a minute. For now, just keep in mind this concept, the concept of parliamentary supremacy. What is this saying? Parliamentary comes from parliament. So parliamentary supremacy is saying that the parliament is supreme, is more powerful than the courts. So parliamentary supremacy is saying that if a past decision, a precedent, conflicts with a law, with a statute, the statute will prevail. The statute will be more important. The statute will overrule. How do we apply this concept in real life? So let me give you an example. Let's say, the Supreme Court of Canada, the highest court in the country, they come with a decision saying that, this is not true, but I'll just give an example. They say that same-sex marriage is illegal in Canada. Actually, it's the opposite. They said that it's legal. But let's say the Supreme Court decided that same-sex marriage is illegal. So in this case, the parliament, the politicians, the MP, the member of parliament, they may pass legislation, a law that says that same-sex marriage is legal. And then this law will conflict with the case law. This law will prevail. In other words, whenever the politicians or the government, they are not happy with the decision that is binding, they have the power to change. If they can, if they want. That's what parliamentary supremacy says. Are we good? All right. So throughout our lectures, there will be some study tips. Those are similar questions to your quizzes or exams, not the same, similar. So you have an opportunity to practice. So look at them and tell me what the answer is.
That parliamentary thing applies to both the private and public, right?
Sorry?
Private and public law.
Which one?
That the parliamentary structure applies to both private and public law.
Yes, yes. And by the way, those questions you don't have in your slides on Learning Hub, so you're most welcome to take pictures if you want. Okay, and just keep them in the lecture slides to give an advantage for those who attend the lecture. So what is your best answer here? And it's okay if you make a mistake. It's a good time to practice. Yes.
That's a C.
C? Maybe. Do you agree? C? Do you have others? B? Bob? Maybe. Who's C?
I think it's B.
C?
B.
B? Who's B? Okay. So stare decisis. What is a stare decisis? Stare decisis says that judges, they are required to follow a precedent in some circumstances, mainly when the facts are similar. And this allows parties to predict the outcome of the decision. So the answer here is C. Stare decisis helps parties to predict a court decision. Okay, be saying prevents a higher court from overruling a lower one. No, stare decisis is not about preventing courts from overruling. Actually, a higher court, they may overrule a lower court's decision when there's an appeal. We'll see this clearly on Wednesday. Okay? So you sue me and I lost, you won. I can appeal the decision. And when I appeal the decision, the higher court, they may change the decision. Okay, but this will be clear on Wednesday. Any other questions on E, D, or A? No questions? Okay, so right answer, C. All right, moving on. So let's talk about Constitution. Constitution formed Canada as Canada is today. What is Canada today? Canada today is a federal government with provinces and territories. Federal government, they have power, but provinces also have power over some matters. So that's what the Constitution, the first Constitutional Act did. The Constitutional Act of 1867 established Canada as it is nowadays. Because before 67, Canada was a colony from the British. So after 1867, Canada became an independent country, or almost independent, because the British still rule at some extent here. Okay, so back in 1867, the provinces, they negotiated this document, this Constitution Act, with the British government to form the country. If you were in Canada back in 2017, you may remember that Canada celebrated its 105th anniversary. Because 150 years after 1867 was 2017. Okay, so that was the 105th anniversary. So this Constitutional Act formed Canada as it is, and also brought the rule of law to the country, to the new formed country. The rule of law is an important legal principle everywhere in the world. And this principle is present in Canada. What does this principle say? It says that the law is applicable to everyone, regardless of how powerful, beautiful, handsome, tall, short, rich you are. So the law that applies to me as an instructor also applies to the Prime Minister, also applies to the billionaires, whoever they are. So that's the rule of law. It may come to your mind that this principle is not present in some countries in the world, countries where there are dictators, in which the law does not affect them, or it affects them in a different way. But most democratic societies, they will have the rule of law. At least black and white, because sometimes in real life, some people are protected from the law. Okay, but at least in theory, rule of law, an important concept, and is present in Canada. There was another Constitution Act. This one is more recent, 41 years ago, 1982. Why is this Constitution Act important? For two main reasons. First, it made Canada fully independent from the British. Since 1982, Canada can change their government, their constitution as they want. They don't need the British approval anymore. Second aspect, this act is important. It brought the Charter of Rights and Freedoms. So since 1982, people in Canada, they have some rights and freedoms protected from violation, from abuses. Freedoms such as freedom of speech, freedom of association, freedom of religion, rights, democratic rights, mobility rights, legal rights, equality rights. So we'll go through some of the rights in a minute. So that's very important because now, or since 1982, those rights and freedoms, they are protected from the Constitution, from the highest law in the country. So this makes the charter very important for us. Okay. And also, the Constitution of Canada, we can conclude saying that it has three elements. It considers as legal, as source of law, statutes. Statutes, they are law passed by politicians, member of parliament, or politicians in the provincial level. We have case law. What is case law? Decisions made by judges. And we also have conventions. Conventions are unwritten conventions, world conventions. They are also valid in Canada. So getting back to the Constitution Act of 1867, again, this act is important because it formed Canada as it is, created Canada as a country, recognized the rule of law, the principle of rule of law in Canada, and third important aspect, it divided the powers between federal and provincial governments. So sections 91 and 92 divide the powers between the federal and the provincial governments. You don't need to memorize the number of the sections or even the matters. Here, you don't need to memorize this. All you need to do is to understand why this division exists and how this division is applicable in real life. So this division of powers says that some matters are of exclusive power of the federal government. Only the federal government can make laws on these matters. And other matters are exclusive powers of the provincial and territorial governments. Let me start my example with the US first. In the US, do you know that in the US, in some states, there's capital punishment for some criminal offenses? But not all states, others don't have capital punishment. Is that right? Why? Because in the US, criminal law is under the power of the states. Each state decides on their criminal law, whether they allow drugs, soft or hard drugs, whether marijuana is allowed, or whether gun is allowed. In Texas, even students can have gun inside the classroom. So if I were delivering this lecture in Texas, I wouldn't make any jokes. I wouldn't. Or I would have my gun there with me. But only in Texas you can have a gun inside a campus, inside a university, inside a classroom. Not other states. Actually, in California, you cannot have a gun, not carry a gun. So in the US, states have the exclusive power for criminal law. In Canada, it's different. In Canada, criminal law is federal. So only the Prime Minister or the federal parliament in Ottawa, they can change criminal law. They can come up with criminal law. So then you may be asking, well, some minutes ago you said that if you have up to 2.5 grams of cocaine, it's not a criminal offense in BC. Yes, and I insist, this is right. But it was the federal government that allowed this not to be a criminal offense in BC only. The BC government requested some years ago, and only this year it came into effect. Only last year, late last year, the federal government allowed. Why was the federal government required to allow? Because of the Constitution. So if you are in a family dinner and one of your family members says, hey, have you read this about people having heroin and it's not a criminal offense, or fentanyl, I don't know, some other hard drugs? And you can tell them, yes, I know. This is based on the Constitution Act of 1867, Section 91. You can tell your family member this. They're gonna be bragging, showing off, you know the law, right? But now you understand why. If you were here back in, when I moved here 2015. 2015, if I had a cigarette of marijuana and I was caught by a police officer, I could be arrested. Only in the end of 2018, the federal government changed the criminal code, saying that up to 30 grams of marijuana is not a criminal offense. It was the federal government who changed because they have the power. And sorry, I think it helps you remember when I give you examples about those drugs. It's not because I'm affiliated or I'm against them. It's not about giving my personal opinion. It's just that I believe that it's easier for you to remember. So criminal law, federal government. Now, Burnaby municipality. Let's say they pass a law saying that if a student at BCAT misses the B law class, they are subject to jail time up to 3 days. And let's say you miss my class and I report to the police and you are arrested. What's your defense? Or you don't have a defense? Sorry, you had fever. Okay, this was an excuse, but not a legal defense. What is a valid legal defense in this case? Can the Burnaby municipality make criminal law? No, they cannot. Only the federal government can. So your best defense is, hey, your law is illegal because you don't have the power to pass criminal law. Clear? Now, example for provincial jurisdiction. Do you know the safe injection sites here in Vancouver? So there are places, mainly downtown, I know, where you can get drug supplies for free from the government. So they give you, how do you call, is it syringes or something? Yeah, they give you those supplies for you to use drugs. Why do they do this? It's in the political belief that by giving you the supplies, they avoid contamination from one user to the other. So they believe it's a health issue, it's a health matter. Okay, when they started with this years ago, the federal government was not happy. They said, hey, BC, shut down those safe injection sites. The BC government at that time said, hey, federal government, healthcare, according to the Constitution, is under our exclusive jurisdiction, exclusive power. We keep them open if we want. And they are open until nowadays. So it's not common that federal government and provincial governments will fight over matters. But when they do, judges will apply sections 91 and 92 and will decide who is right. Is this clear? Again, you don't need to memorize the matters, but you need to understand this concept. Okay, you have a question.
But can the parliamentary supremacy change the law regarding that?
Well,
They enforce if they try to.
only the parliament, no, because this law can only be changed if the constitution is changed. Sections 91 and 92, they are part of the constitution, the 1867 constitution. So the parliament and all the provinces and territories, they need to agree for a new constitution act.
It is possible, right?
Yes, it's very difficult, but it is not based on the parliamentary supremacy. Because for a constitution to be changed, it requires agreement not only from the parliament, but also from all provinces and territories. Okay. All right. Are you following so far? Are we good? Yeah, according to time, I think we're gonna be finished by 7-8 p.m. Okay, no, I'm joking. You know, I'm joking. So now let's talk about the branches of power. So how the country is run, how peace is maintained, at least theoretically in the country. So in the country, we have 3 branches, and most countries will be the same, most, not all. So in Canada, we have the legislative branch, and I'll tell you in a minute who they are. We also have the judicial branch. Judicial, who are they? Judges, courts. And we have the executive branch. I'll tell you in a minute who they are. So they exist so that the country is maintained in peace and order. Those branches, again, legislative, executive, and judicial. We already know that the judicial branch, they are the judges, the courts. Why do we need to know them? Because we know that they make law. What kind of law do they make? Case law, precedents, past decisions. But now, who belongs to the legislative branch? The legislative branch, they are politicians. But as we just saw, sections 91 and 92, in Canada, we have politicians in the federal level and also politicians in the provincial level. So both politicians, they are part of the legislative branch. What kind of law do they make? They make statute law. They make legislation, they make written law. And then statute law can be used for the parliamentary supremacy. So let's say, as I said, court decided that same-sex marriage is illegal. This is, again, wrong, but just an example. And then with statute law, they can overrule the case law. Okay? And who belongs to the executive branch? Prime Minister and their cabinet in the federal level, and the premier and the members of the assembly at the provincial level. Sorry, the premier and their cabinet also in the provincial level. The assembly is the legislative body. Okay, so all those 3 branches, they work in harmony in the country, at least theoretically. Okay, because how does this work? Well, those people here, they are running, administering, managing the country. When they have an idea about new laws, new rights, new obligations, they send a proposal to the politicians. So the politicians will discuss, debate, eventually approve or not. And when there are disputes among private individuals or disputes involving the government, we have the courts to decide, to have a final word, to say who's right, who's wrong. Is this scheme clear to you? So the 3 branches, theoretically, they work in harmony. Each has its own function, its own duties. Okay, so it's important to understand this. And when I said here that the Constitutional Act of 1982 made Canada fully independent from the British, let's just remember that Canada is still part of the Commonwealth. And this picture here is outdated now since last year because the Queen is not there anymore. It's the King now. So apologies for that. But the King Charles III, is the head of the state of Canada. Because Canada, along with Australia and some other countries, they are part of the Commonwealth. Okay, but you already know that if Canadians want to change their constitution, they can. They don't need the approval from the British. Okay, and in Canada, who's the person that represents the king now? It is the Governor General. Okay, so the Governor General is the one representing the head of state. The head of state is usually the one who travels and has diplomatic relations with others. The one that is managing the country, proposing bills, proposing laws, etc., is the Premier. Okay, sorry, Prime Minister, Premier in the provincial. Are we good? So that's how the system of government of Canada is. With regards to Indigenous rights, self-government, is important to remember that in Canada, it is recognized the right of self-determination and self-government of Indigenous peoples as an inherent right. Inherent right means it's not in the Constitution, it's even before the Constitution. So those rights, they existed before Europeans settled here, before the British had settled here. And the law, the Constitution, the legal system, they recognize those rights. Canada became part of the UN Declaration of Rights of Indigenous Peoples in 2017, if I'm not mistaken. Nowadays, and see, you don't need to memorize those names, right? You need to understand the overall concept. But I mentioned this, those to you just to reiterate the importance. We already have 22 self-government agreements. Those agreements, they were made between Indigenous peoples and the federal government, or Indigenous peoples and provincial or territorial governments. Okay, so it means that for in some Indigenous jurisdictions, they have their own rules, their own laws, and the legal system, the executive branch, the legislative branch, they all respect those rights there. And we also have section 35 of the Constitution Act of 1982 that not only recognizes but also affirms the existing Indigenous and treaty rights. Okay, so that's also important to keep in mind. Well, one more concept here, and then we can break for more 10 minutes. So paramountcy, another concept. This concept says that if federal law and provincial law, if they conflict, the federal law prevails. Okay. So the federal government has slightly more power than the provincial or territorial governments. This doesn't happen frequently, but if it does, this concept will be applicable. All right, let me share this with you. Whenever I have a crossed slide like this, you don't need to focus on this. I won't be focusing on this, but I keep it here because it was provided by the publisher. So if you want to read or study, it's fine, but it's not for exams, okay? You don't need to focus on those. So before we talk about laws, let's break. 10 more minutes for a break, and then we'll be back. If you can be back 3:30, please. please. All right, so I told you that the legislative branch, they pass legislation, they make law, they make statutes. So how does this work? Well, I'm gonna be very, very brief. You can read more about this in the textbook, or you can read a bit more online. But the way it works in Canada, it is the Prime Minister or their cabinet, they propose a new law to the Parliament, and then the Parliament, through what they call first reading, second reading, and third reading, in other words, they will introduce that proposal, they will debate, they may modify it slightly or not, and then they will approve or not approve. So back in 2015, I was not here, but I read that Trudeau had promised to decriminalize marijuana possession. And then after Trudeau became the prime minister, then Trudeau and their cabinet made a proposal to the parliament so that the parliament would change, modify the criminal code so that whoever possessed up to 30 grams of marijuana would not be committing any criminal offense. So they went through this and that became law. Okay, so new laws are passed like this. If I can give an example at the provincial level in BC. If you were here in BC last year, the end of 2021 and the beginning of 2022. So at the end of 2021, the Premier proposed to the Provincial Assembly the introduction of 5 paid sick days. Because before, it was not a right. If you called in sick, you would not get paid. Then the politicians at the Provincial Assembly, they went through the introduction, debate, and they finally approved. And that proposal became law January 1st, 2022. So that's how new laws are passed. But again, in a very brief way, in a very basic way. Once the parliament, the legislative branch, could be the parliament in the federal level or the assembly at the provincial level, once they approve, then the law has to gain what we call royal assent. It's the signature of the governor general. Sorry, yeah, the general governor or the governor lieutenant here in the provincial level. Okay, it's just they sign and the law, the proposal gains legal effect. So that's how laws in a very brief way are made. Now, this is the last subject or the last part of the lecture. Now we're going to discuss and talk about protection of rights and freedoms. We have rights, we have freedoms that have to be protected. And who protect them? We'll see in a minute. What are those rights? What are those freedoms? We'll also see in a minute. What is important to understand initially is that there are 2 different ways rights and freedoms will be protected. 2 different ways. And why am I emphasizing this? Because it's really important in our daily lives. One way is when the government or any governmental officer violates our rights or freedoms, breaches our rights. This is one way. Another way is when private institutions, private parties, another person discriminates on us. There is no government in this second. Why it is important? Because if it's the government, I will sue the government in courts. Courts will have a final word. If it is a company or a person who discriminates on me, I don't sue them. I file a complaint with the Human Rights Tribunal. So it's different. Okay? When the government violates our rights or freedoms, we rely on the Charter of Rights and Freedoms as protection. And when I discriminate on you, you rely on human rights legislation, human rights code of BC. It's different because I am not the government. So you cannot rely on the charter. Okay, so the charter is important because it sets out our rights and freedoms, and if they are violated by the government, the courts, the judges, they will have a final word. I'm not sure if you were here during COVID, but during COVID in Vancouver, in BC, during Christmas time 2021, gyms were closed. Or before Christmas, around October, December, well, gyms were closed. It was a health order. In principle, it violates mobility rights. We have a right to go to a gym. They have a right to have a business open. In principle, it's a violation of the charter. Who is violating? Who was violating? The government, the provincial government. It was a health order. So if any person or businesses felt violated on their rights in this case, they would sue the provincial government. And the courts, the judges would have the last word. Is this clear? I haven't heard any cases about this, but that's how it works. If a government or a governmental officer, like a police officer, if a police officer knocks at your door tonight, let's say tonight, a police officer knocks at your door. You open the door, you say good evening, and they say, excuse me, I want to search your house. Do you allow them to come in and search your house? You don't? Why not? You have rights. You're right. You are right. You have rights. What is the condition that allows a police officer to search your house?
Warrant.
With a warrant. They need to show you a warrant. So if they say, hey, excuse me, I want to search your house, you have to ask them, can I see a warrant? Can I see a judge order allowing you to come into my house? If they say, no, I don't have one, it's illegal for them to enter. See, I cannot give you legal advice because I told you I'm not a Canadian licensed lawyer yet. But if it were me, I would allow the police officer to go in and search anything. Because whatever they found without a warrant could be illegal. Okay? If they search my house without authorization, whatever they find is illegal, cannot be used against me. But this is not legal advice. Okay? We just know that police officers cannot enter our house, cannot search our house without a warrant. If they do so, we rely on the charter. We sue the government. Is this clear? So let's talk a little bit more about the charter. Let's use the health order example again. So let's say October 2021, there was a health order, gyms should be closed. Also, I could not have visitors in my house, so mobility rights affected. I decide to sue the government. I decide to challenge that order in court. What happens? The judge will have to answer two questions. First question, is the challenged order, is the health order in this case, a violation of the charter? If they say no, the lawsuit is ended. There's no second question. You say, no, it's not a violation. Okay, continue. If they answer yes, it's a violation, they have to answer a second question. Is this violation justifiable in a free and democratic society? In other words, because of the pandemic, because of the death, all the situation, is it justifiable that people should be prevented from visiting others, going to the gym for some time? I haven't seen any cases of this. I also have the same opinion. I believe, yes, it's justifiable. Others may believe, no, it's not justifiable. But that's the answer, or sorry, that's the question the judge would have to answer. So whenever there's a violation, it doesn't mean the violation is illegal right away. No, the judge still has to assess whether that violation is possible or not. Because it may be possible. Okay, for some time. So that's how it works with the charter. Let's look at some freedoms and rights. I won't discuss all of them with you, but I just want to call your attention for some. So we have freedom of conscience and religion. So we can be member, we can be part of any religion in Canada. Okay, and we cannot be discriminated. We cannot have this right, this freedom violated by the government. We have freedom of thought, belief, opinion, and expression. But I want to call your attention here. After the class, can you tweet that the B-law instructor is an illegal worker in Canada? Under your freedom of expression? Can you tweet, or can you Snapchat, or can you post on Instagram or whatever, or even LinkedIn? I don't know, any.
Yeah.
Can you do this? No,
I can-
yes.
I can challenge it.
You can post, but if you do so, you may be causing me harm. So I may sue you for compensation.
Yeah.
What I mean here is that our freedom of expression is not unlimited. It's limited to the extent we do not cause others harm. And this is important in this social media world we live nowadays. Another example. After class, can you tweet that the B-law instructor is boring, has a bad voice, has no methodology to explain, etc.? Can you tweet this?
Yes.
Yes, you can, because this is freedom of opinion. And it's not based on a false statement, it's your opinion. Right? So we have to differentiate. Our opinion has to be based on true facts. Because we don't have protection if we issue false statements under the freedom of expression. Let me give another example. We have freedom of peaceful assembly, peaceful, and association. So do you remember the convoy, truck convoy 1 or 2 years ago in Canada? Yeah. They went to Ottawa. Could they get together to protest against the vaccine policy and COVID measures? Yes, they could, but on a peaceful way. And I am not saying I am against what they did or I am for. No, it's not about my personal view. It's about the law. Yes, they could get together, go to Ottawa and protest, but they cannot get together to commit acts of illegality, threaten, destroy public premises, carry guns or other things. This they could not. Right? So our freedoms, they are not unlimited. They have a limit. They have to be within the parameters of law. That's what I mean. Okay. All right, moving on. Democratic rights. Well, it's about election because Canada is a democratic country. Mobility, I gave you an example on the health order. Legal rights. The legal rights is the one related to the search warrant. So if there's no warrant and a policeman searched my house, I will challenge all evidence that was obtained under sections 8 and 9 of the charter. I will say, hey, judge, okay, they found illegal activities evidence in my house, but there was no warrant. So that evidence is illegal. You cannot use it to find me guilty. Okay, so that's legal rights. We also have another one here. Right to life. Oh, security of person. Security of person is the one to be used for those who are against mandatory vaccination. Because security of person means my body is protected. So I cannot be required to get a vaccine. Okay. Again, I'm not saying I'm for or against. Actually, in my opinion, I am for vaccines. But we're talking about the law. The law gives us the right of security to person. Right to life. Right to life. There are religions that do not allow blood transfusions. So there's a real case in Canada where a newborn needed a blood transfusion. Their parents said no because our religion doesn't allow. And you may remember, freedom of religion. It's a freedom under the charter. But there was this medical association that sued the parents saying, hey, the newborn has a right to life. So the judge in that case had to decide over freedom of religion and right to life. That judge specifically decided for the right to life. You don't need to agree with the judge, but that's what the decision was. Okay, so that's how we apply this. And I'm giving you just examples. Equality rights. Everyone is equal. Law has to be applicable to everyone. Language rights. For us foreigners, when we arrive in Canada at the airport, we see signs in English and in French, because those are the two official languages of Canada. So those are some of the rights and freedoms we have under the charter. If we are ever violated on them, we will sue the government. And whichever governmental department that violated that right or that freedom. Are we good? And then the court will decide. Okay, question for you.
Question about the motivation.
Yeah.
Some people don't really want to, and the child have to meet the age to get vaccination. If the other parents don't let the child get the vaccination and get the virus and this to our child because our child didn't in the time of vaccination, what happened if my child was get a sick because they believe what they're supposed to do? Okay.
Remember, I cannot give you legal advice for a specific situation, but in my field, the fact that they decided not to have their child vaccinated and that caused illness on someone else, they are liable for all the medical costs and any other consequences this other child. That's my view, that's my legal view on this, but it's not I'm not giving you legal advice on a specific situation, okay? Because the cause of the illness was the lack of vaccination. But in this lawsuit, you need expert evidence. You cannot just say, doctors have to attest that the cause of the illness was the lack of vaccination in this child. And that you may be successful. What is the right answer here? Don't be afraid to make a mistake. This is a safe place. And this is the right moment to learn and make a mistake if you ever make a mistake. What is the right answer? C. The passage of the charter increased the power of the courts. Why? Yeah, go ahead.
Because now the court's gonna make the decision based on if the charter was violated or not.
Exactly. The courts have the final say. So the government issued that health order. If I believe the health order violated my mobility rights or whatever other rights or freedoms I have, I'll go to the courts. And the courts will have the final word. So as a consequence, yes, the charter increased the power of the courts. Okay, so remember, legislative branch, executive branch, and judicial branch. Remember the parliamentary supremacy. So the parliamentary supremacy says the law overrules case law, right? But if a law, any given law or any given order violates the charter, the court will have a final say. Okay, so we are now protected by the courts. And this is good news. Because before the charter, if the government violated our rights, we didn't have power at the courts to protect us. So this was great victory for us, the introduction of the charter as a constitutional right. Okay, on Learning Hub, I have shared with you a link with more information on the charter. Because the charter gives us so basic rights and so basic freedoms, I highly recommend you to read the content of that link. Okay, it's not for exam, you don't need that for exam, but just for your life, if you want to read more, if you want to know more about the charter of rights and freedoms. Okay, now the last part is, so I told you before that if you discriminate on me, or if I discriminate on you, or if a company discriminates, it's not about the charter now, because it's not the government. Now it's about the human rights legislation. And in BC, we have the Human Rights Code. In BC, we also have the Human Rights Tribunal. So it's a specialized tribunal, similar to court, but it's not part of the court. If I believe I was discriminated, I will file a complaint at this Human Rights Tribunal. I will describe what the situation was. So I will say that a student in my class discriminated on me because I'm from Brazil. So discrimination based on ethnicity. And I will file a complaint. The tribunal, the decision maker, will render a decision after the violator or the discriminator has had a chance to give their version of the story, etc. But after the evidence is there, decision maker will render a decision. I may get an apology letter, I may get compensation. Let's say Tim Hortons. Tim Hortons has a job posting for a server, and they say only women should apply. Is this discrimination? Based on what? Gender. Based on gender. Is Tim Hortons the government? No, it's private. So it's human rights legislation. So I will apply. I'm not a woman. So I will file a complaint at the Human Rights Tribunal against Tim Hortons. The tribunal may issue an order for Tim Hortons to correct the job posting. The tribunal may also issue an order to pay me some compensation. So the Human Rights Tribunal functions similarly to courts, but they are not part of the court system. Is this clear? So remember 10 or 15 minutes ago when I emphasized the difference between violation from the government and discrimination at large. Because the procedures are different. If the government violates, we sue, we go to courts. Courts will have a final say. But if we are discriminated by private party, another person, a company, human rights complaint, we file. Is this clear? Yes.
If it says preferred instead of only, can I still file a motion? Instead of only women, it says women preferred.
But it may be. I cannot give you a firm answer that this is discrimination, but it may be discrimination. Because with regards to preference, it's common that some companies, they have a preference for permanent residents instead of work permit holders. I see this preference as legal, not discriminatory, because as a company, if I hire someone who has a work permit, I have no guarantee the work permit will be renewed. So I may lose investment, time, etc. But a preference on gender, I don't think it's legal, but it's not a firm answer. The tribunal may differ. But what is the reason for preference in gender? I don't see a legal reasoning for this. Okay, so it depends on what type of preference it is. Okay, I know that for tenancy agreements, gender discrimination is okay. So I have an apartment, three bedrooms, and I'm offering one of the bedrooms for someone else. And I only want men living with me. It's fine. The tenancy law allows. But it's because of living. Okay, but this discrimination is an exception. The general rule is that there can't be discrimination of gender. Okay. So that's what I wanted to share with you with regards to discrimination. By the way, just to emphasize, the protected grounds will be gender, religion, ethnic origin, race, age, disabilities. Okay, so we cannot be discriminated on this. We just can't. Okay? We have rights. Our rights are protected. And then, as I said, we file complaints at the tribunal, Human Rights Tribunal. Duty to accommodate, I will discuss in more details in employment law. So this is what we saw today. And I know today was a bit longer as a chapter, but we're still talking about the basics, the fundamentals. So we cannot discuss about contracts, about torts, about business organizations if we don't know these basics. If we don't know what the law is, the source of law, how the government system is in Canada, court system, etc. So this is what we saw today. On Wednesday, we'll be discussing about disputes. How do we solve disputes? We may solve disputes out of courts or with the courts. So this is what we will discuss on Wednesday. Are we good? Yep. Questions, comments? No? Okay, let me just stop here.